together. And for those who don't know me, my name is David Christie. I'm one of the academic strategic leads at the law school at Robert Gordon University and specialise in construction law. And I am generally the academic host for these webinars, or these particular construction law webinars. I'm delighted to be welcoming back my good friend and I was going to say colleague, I'm not sure if that's exactly the right term, but former collaborator, Dr. Waleed El-Nimr, a returning webinar speaker coming to share some further thoughts this evening. His topic tonight is around time at large and constructive acceleration. These issues in particular following the pandemic will be particularly important, but always topical and always thorny issues for construction law folks, whether they're lawyers or other construction professionals. So always good to hear about that, and always good to hear from Dr. Waleed. For those of you who don't know, Dr. Waleed is a graduate of our construction law and arbitration program. And after leaving us in 2009, he went on to the University of Salford, where he completed his PhD in time bar clauses and their enforceability in 2017. He has many decades of experience in construction contracts as both an expert witness, adjudicator, arbitrator, and counsel, and is the contracts director at Hill International in Cairo. I was delighted to be on a panel with him on the stage in Cairo earlier this year. In the old times, he was probably one of the last people I saw before the lockdown. So good to see him, albeit virtually, this evening. And as well as working for Hill International, he's also an adjunct assistant professor in the construction engineering department at the American University in Cairo. So one of the most knowledgeable people on this particular subject that I think we could hope to welcome. And so I look forward to hearing from him this evening. So welcome all, and welcome Dr. Waleed.
Thank you very much, David. That's a very warm and kind introduction. I don't think I have too many decades of experience, not that old, but just maybe 2 decades or something. But thanks a lot for this opportunity to speak again. And I'm always delighted to speak for events by RGU. And I'll just share my screen now. Okay, so the presentation is really entitled Time at Large and the Constructive Acceleration, Two Faces of the Same Coin. And basically, I just wanted to start with a few questions. First of all, have you heard of time at large before, this phrase? And you can answer that by basically, just by a show of hands, if that's possible. Okay, so my second question was so what is your understanding of time, of course, of time at large? I know this is a pretty extensive question, but all I'm asking for is just a few words in the chat box, just so that we can see what is your understanding in general, just a few words. So no liquidated damages, no time of completion, no defined completion date. Liquidated damages, no extension time, no set completion date. Okay, so then, okay, thank you. So my other question is, have you encountered a time at large situation in any project? And by time at large, I am talking about this issue of no completion date, or that there's no the completion date of the project has lapsed and there's no extended completion date, and so time at large, figuratively speaking. Has anyone encountered that position in your projects? Yeah, I see a lot of yeses there. Yeah, yes, often, yeah, for sure. Okay, so we can say that there's most of you have encountered this. So basically, first of all, I don't proclaim to be an expert in time at large and constructive acceleration. However, I'm just, the whole point here is just to briefly summarize the discussion, the concept of time at large, and to also, for those who don't know, to discuss the concept of constructive acceleration, also very, very briefly, and then to find the common ground between them. And this is going to be the objective of this presentation, or basically the coin that I'm referring to in two faces of the same coin. So when we look at time at large, we have to separate between the old days and you can say the modern days. Old days, modern days being the past few decades. So basically in the old days, you have the original contract duration spanning between the commencement date and the completion date. And then we have an employer's act of prevention. Act of prevention meaning that there's an employer delay that comes at the completion date of the project or prior to the completion date of the project, and that employer's act of prevention prevents the contractor, does not enable the contractor from completing within the time for completion. That results in a extended time for the contractor to complete. And in those old days, there was no extension of time mechanism in the contract. So in that case, that extended period, the courts would rule that time is at large, and the contractor should complete within a reasonable time, and the court would really come to what is considered a reasonable time. It might not be this time that is shown here on the red, but it could be something that is less than it, or depending on the court's judgment. But most importantly, liquidated damages would not be applied. Now, one thing I also did not mention is that, of course, this presentation will not be heavy on cases. So it's just like I said, provides a brief on both concepts, and it's a thought-provoking thing that we can think of what is common in both of these concepts, time at large and constructive acceleration. So when I say employer's act of prevention, this can be one of two things. First of all, it can be a perfectly legitimate act, which is generally a variation, and the variation can be in the form of a modified scope of work, or it can be through additional work, for example, or it's a breach of a contract. That means there are delays and lack of site possession, for example, delayed drawings, anything that the employer has violated his obligations under the contract that delayed the contractor. So in both cases, these are acts of prevention from the employer. In the modern day context, we will have the original contract duration spanning from the commencement date into the completion date of the project. But then we have an employer's act of prevention, and that delay prevents the contractor from completing on time. However, but now there is an extension of time mechanism in the contract itself. So therefore, there is a delay that occurs to the project, and if the contractor fails to operate this contractual machinery for the extension of time, in that case, the time would not be set at large, and liquidated damages would be applicable on the contractor. So now that really, that modern day context has, the difference is that there's a mechanism for an extension of time in the contract. And when we think of this issue of the mechanism of time in the contract, then this really triggers another debatable topic, which is that of time bar clauses, for example, that there's a time bar clause, a certain limitation on the number of days that the contractor can submit, for example, a notice of claim, and the detailed particulars for that claim, and the fact that there's a act of prevention by the employer. So in that case, say, for example, there is a COVID-19 situation, which is, it's not really an employer's act of prevention, but it's something that prevents the contractor from completing on time. But the contractor must provide a notice to be entitled to an extension of time, for example, and the contractor does not provide this notice within the time. However, it is for sure it has a clear impact on the completion date of the project. So of course, another clear clear example is if we have, for example, a variation or another, like I mentioned, a breach, employers that delay in the drawings. And so in that case, you'll have the tension between the contractual mechanism, which is the for extension of time, and the prevention principle, which is that a party cannot benefit from its own breach. And therefore, in that case, by this modern day context of time at large, really the time bar clauses, this is really what would be prevalent, is that you have to operate, the contractor did not operate the contractual machinery by not providing, say, the notice on time, and therefore the time bar clause would prevail and liquidated damages would be applied, and the time at large would not be applicable. Now, the EOT mechanism in the contract. Now, let's say from a FIDIC standpoint, for example, and this is the contract form that we will be using in this, using as a reference in this presentation. Let's take the FIDIC 2017 Red Book, for example. There is a clause 8.5, which is the extension of time for completion. And that is the clause that the contractor should start with for any claim regarding an extension of time. And by the way, of course, I'm sure most of you know this by now, but when we talk about COVID-19, you'll find that item D here talks about epidemics. And that epidemic, that's where a contractor would really ask for an extension of time, not necessarily force majeure, because force majeure, it's limited to any act that prevents the contractor from proceeding with the work. That's different than suffering loss of productivity because of COVID-19. However, if we continue, so the mechanism, the extension of time mechanism, starts with 8.5, and 8.5 mentions that any delay, impediment, or prevention caused by the employer's personnel, which can include the engineer under the contract and other contractors on site, that is really one of the factors that entitles the contractor to an extension of time. However, the contractor must operate the contractual machinery, as we mentioned, which is mentioned in clause 20.2. So I'd like to ask you another question. In your opinion, what does the contractual machinery in modern contracts comprise of? Of course, I know this is also maybe an extensive question, but I mean, what is, in just, if you can just say 1, 2, 3, 4, very, very briefly, what are the steps? What are the steps for the contractual machinery? For a claim, for example, you can just write in the chat box. Notice, yes, okay. Terry mentioned the notice. Notice, but of course, it's not just a notice. I mean, I'm talking about generally speaking. It starts with the notice, but what else? Particulars, okay. System of processes, okay. Just a few. Okay, EOT notice, then delay analysis, okay, and up-to-date data, details of claim, cause, effects, conflicts, okay. Okay, so these are early warning schedule. Okay, so now this is really what I'm getting into, because that's what I expected. Now let's look at the machinery in the FIDIC contract. Again, I'm using it as a reference, and let's really look at this machinery, because that's really the machinery. This machinery applies in all other contracts as well, any standard contract. So first, as you mentioned, it starts with a notice, and that's in 20.2.1. And then there's the engineer's initial response, that's 20.2.2. And then there's the provision of contemporary records. The contractor must keep contemporary records in relation to the claim, and that's 20.2.3. And then the contractor submits a fully detailed claim, that's 20.2.4. And then finally, the engineer provides an agreement or determination to the claim, and that is detailed in clause 3.7, but that as far as the claims procedures are concerned is 20.2.5. And there are a few other steps in the contract, but that's not really, it's not really germane to our this presentation here. So this is basically the mechanism for the contract, for a contractor to the contract extension of time machinery in the contract as a whole. And I've purposely colored them. You see the blue and the green, and the blue really reflects the contractor's role in the machinery, whereas the green is really the engineer's role in the machinery. So if we focus here, and this is really the point that I wanted to mention, and as you can see from your responses in the chat box, the most familiar, I mean, the most common, when we talk about contractual machinery, we always think of what the contractor should provide. The notice, the particulars, so on and so forth. However, what's very crucial is the engineer's role, which is the initial response and the agreement or determining the claim. So, and what I'm getting at here is when we talk about time at large and failure to operate the contractual machinery, this failure to operate the contractual machinery can arise from the engineer, not just from the contractor. So that can set a time at large in a modern day context. Now, moving on to the fifth poll question, I wanted to ask you if you are aware of the concept of constructive acceleration. Did you hear this term before? If by raise of hands, you can just you can let me know. Okay, so okay, there's a lot of yeses in there. Now, constructive acceleration has a lot of has been getting a lot of is very, very well known in the States, especially. And I happened to ask an U.S. claims expert in this, like maybe 2 years ago, do you know about is time at large? Is that concept known in the States? And he told me that no, it's not known. It's not known at all. It's not really used at all. But what's the equivalent of time at large is really constructive acceleration. And of course, here in Egypt, we are well versed with time at large and these concepts. But also in Egypt, constructive acceleration is not really known. But to demonstrate to you how famous this and big this issue of constructive acceleration is, I'd like to share with you some articles, journal articles, just headings that have been published in the States. I'm a member of the Association for the Advancement of Cost Engineering International, AAC International, a US-based association. And they have like you say, a virtual library, just a collection of all the journals that have been published since the association was established in the 50s. And if you can see here, if we'll just look from the 90s, for example, you have this article, for example, in 1995, proving and pricing constructive acceleration claims. You have the constructive acceleration waking the sleeping giant, the basics of constructive acceleration, that's in 2012. The previous one was 2005. You have just last year also, there was this in the annual conference, we had the understanding and applying elements of constructive acceleration. And there's really a lot of court cases in the States that talk about constructive acceleration. None mention time at large because that's not really known in the States, but that's another very pressing and very widely used concept in the States. So if we discuss that, let's first start by discussing the types of acceleration. We have first a voluntary acceleration. This is when the contractor voluntarily decides to accelerate the works, and the contractor would then because of, for example, there is the contractor knows that he's late, so the contractor would want to catch up with progress. So the contractor would, employ those additional resources to speed up and try to catch up with progress. So that's something that's really at the contractor's initiative to try to accelerate the works. But then you have directed acceleration, which is maybe that's something that is also common, where the employer directs the contractor to accelerate, and the employer, for any reason, for example, the employer needs something finished early, or the employer, due to some urgent demand, needs to use a certain part of the work or have it completed early. So the employer instructs the contractor to accelerate. So that's a directed acceleration. And then, of course, there is constructive acceleration. That's the third kind, and that's what we will focus on. And basically, what is constructive acceleration? It's very clear from, if you look at this definition that is in one of those articles that I shared with you, the last one being the 2019 one. And it mentions that, especially if we look at from here, that instead of providing a justified time extension when the contractor has properly requested it, the owner does not timely adjust the completion date, so and thereby requiring the contractor to complete the work earlier than would be allowed by the time extension. So this action constructively forces the contractor to accelerate to finish the work earlier than the date substantiated in the time extension request. So basically, the contractor asks for a time extension. The employer or the engineer does not provide a justified time extension, and the contract completion date is not adjusted. So far, I believe this sounds familiar, like time at large. And then so the contractor's reaction here in this case is that, okay, so the contractor will accelerate because he has to, because of the inaction of the employer or the engineer, and therefore the contractor would claim for this extra cost for the acceleration, which is really the main reason for that really is the engineer and the employer. So again, if we look at the illustration again, we'll find that there's an original contract duration, and there is an act of prevention by the employer, and this act of prevention is followed by a extension of time claim by the contractor, and there is of course that act of prevention results in an impact to the schedule, and that impact should have resulted in a reasonable extension of time. However, this extension of time is not granted, and therefore, as a result, the contractor accelerates. So for example, you see this red here. This is the impact, really the reasonable impact of the act of prevention. However, the contractor accelerates to complete by this date. So they actually completes earlier than would have been reasonably expected, and that's the actual completion date due to constructive acceleration of the contractor. So that's really what summarizes what a constructive acceleration is like. However, to constructively accelerate, there are some conditions that the courts look into so that you can see that they can determine that the contractor has can correctly make a claim for constructive acceleration. And of course, in a constructive acceleration setting, if the employer applies liquidated damages, and of course the liquidated damages are returned to the contractor in addition to all the extra costs that the contractor has borne because of the acceleration. So what are these prerequisites? The first one is that there must be an excusable delay that has happened. So the delay must have been perfectly excusable, and there's no doubt that it's a justified delay. The second thing is that the contractor submits an extension of time claim. Okay, so that sounds familiar. That's the extension of time mechanism in the contract, right? So the contractor submits the notice, contractor submits the detailed particulars, and the contractor basically complies with the requirements in the contract. And then the engineer or the employer fails to provide the EOT. Now, this second step and the third step, these are all the contractual machinery. Remember, if we go back to the FIDIC clause in the contract, then that is an example of the contractual machinery. one by the contractor, another rule by the engineer and the employer. Here, the engineer and the employer fail to provide the extension of time, and therefore the contractor here must notify the employer or the engineer of that he intends to constructively accelerate. So that's a pivotal prerequisite to constructive acceleration claims. And once the contractor provides a notice, then comes the hardest step on the contractor in this process, which is that the contractor actually accelerates the progress. And of course, if the contractor actually accelerates, then that means, of course, that the contractor will employ additional resources and expend more money. However, this is critical for the success of this claim. So all 5 of these steps must be satisfied so that you can really call this a successful constructive acceleration claim. So that really is what I want to mention regarding the constructive acceleration and time at large. But I wanted to ask you, so in this presentation is entitled that they are time at large and constructive acceleration they're all 2 sides of the same coin. So in your opinion, what is the coin that I mentioned in today's topic? What do you think is the main objective? What do I mean by this coin? If you can briefly insert your input in the chat box. So there's a question, but I just wanted to know your opinion of what is the coin? What is agreed completion date? Okay, what else? Time. So basically, what I'm saying, what do they have in common? Like what's the main objective, do you think, between the lack of EOT awards? No, it could be liquidated damages, uncertainty. The coin is rejection from the employer to a legitimate claim. Liquidated damages, failure by employer to award EOT or contractor entitled. Okay, so basically, a few of you, yes, I think captured the point, is that when we talk about time at large and we talk about constructive acceleration, maybe there's a lot of attention, maybe not so constructive acceleration, but when we talk about time at large, there's a lot of attention on the contractor and the contractor's role and the contractor failing to operate the machinery, and that the liquidated damages should be applied on the contractor for failure to operate the machinery. And there's less attention on the engineer's role and the employer's role. And if you look at time at large and constructive acceleration, you'll find that a common factor that can set time at large and a factor that can result in constructive acceleration really has to do with the employer's or the engineer's failure to operate the machinery itself. So, and I really mention this because in a lot of projects, actually the vast majority of the projects that I'm involved in, and maybe this sounds a bit strange because I am representing the engineers, so I'm out on a limb here, but really it's a fact. There's a lot of undermining, I think, in the industry about the role that the contract administrator or the engineer plays when they assess a claim. So for some odd reason, a contractor submits a claim before the contract completion date, and this claim is not really given adequate attention. So it's not maybe responded to at all, or it's responded to with minimal effort, or and a lot of, I think what's happening in the industry is a lot of practitioners would just say, it's a fragile claim. It has no base. It doesn't deserve a response. It's, the contractor is just late anyway, and then a flimsy response is provided, or no response at all. But I think there's little attention to the fact that the spotlight is really on the engineer to demonstrate that the contract machinery has been employed. The contract machinery is not just the notice and the detailed particulars, but also the initial response, as we mentioned in the FIDIC contract, the determination. And even that determination process is a lecture on its own merit. So, the determination process is not just a letter of a decision. There has to be consultation between the parties, and there has to be an endeavor to reach an agreement and all this stuff. So that's the coin. That's there's really two roles that should be played here, which is and this is the conclusion of this presentation, is that for effective administration of extension of time claims, each of the contractor and the employer, they all play a part. Each of them plays a part regarding operating the contract machinery. So the first thing is that the employer and the engineer must promptly process any extension of time claims to which the contractor is entitled. We cannot just undermine the claim and not provide a well-reasoned, detailed response to this claim, even if it's presented at the last week of the project. This is very, very, very important. The second thing is, of course, the contractor must comply with the claim submission procedures in the contract. So the contractor must submit the notice on time. The contractor must submit the detailed particulars on time. And to share with you also an experience, maybe this is a phenomenon that I'm also experiencing. I don't know if you all agree with me or not, but a lot of contractors would promptly submit the notice, for example, but they do not submit the detailed particulars for each event. So for example, again, in the fitted contract, I'm sure this is not just the fitted contracts, it's most contract forms, you have an event that takes place, and from that event, you provide the notice and you provide the detailed particulars for that event. The detailed particulars are not for a group of events, they're for that event. And the purpose is that the employer can take measures to understand the impact of that event. So I'm raising this because a lot of contractors provide the notice, and then periodically, after say every 2 months or something, they provide this lump a series of claims into, and say this is extension of time claim number 1, for example, and it has a compilation of like 10 events or something like that. So they just provided a notice, and then they provided compiled detailed particulars. And the problem with that is that the employer did not know the effect of event number 2, for example, at the right time, so that the employer can make a decision, for example. And that, in my opinion, constitutes a failure by the contractor to operate the contractual machinery at the same time. So the thing that I'm trying to say is that there are roles that have to be satisfied by each of the employer and the engineer and the contractor in order to properly operate the contractual machinery. It's not just the contractor, for example, and that can help in alleviating the problems that result from time at large and from the propagation of constructive acceleration claims. Now, with that, I thank you very, very much for your attention, and over to you, David.
Thank you for that, Waleed. That's very interesting. Particularly striking, I think, about the coin. And as I was keeping a note on what you were saying, I thought this point about the role of the engineer is very important. So I was very glad that you circled right back to that at the end as well. I think so many of the cases we have, especially in the common law jurisdictions, because they tend to be, they are adversarial between two parties, we tend to think in terms of the two parties in combat with each other, but actually there is a three-party process usually set out in an EOT mechanism between the employer, the contractor, and the contract administrator or the engineer. And I think thinking of it not as a battle between two, but as a process which is working between three people, all with different areas of expertise or knowledge in the situation, is a very useful way to think about it.